Hello and welcome to Immigration with Andrew. In this video, we'll be discussing the new Parole-in-Place program for the Keeping Families Together program with Biden and an update about a lawsuit that was just filed this morning. Well, hello. I've been meaning to get this video up all week. Today is Friday, August 23rd of 2024. I've been meaning to get the video up to discuss Biden's parole program. It's part of the Keeping Families Together program. It started on Monday this week, just a few days ago. I've got a few of these under my belt now, so I thought it'd be good to do a quick explainer on it. As I was preparing for the video, though, we got the news that a complaint was filed yesterday by the state of Texas and I believe 15 other states to stop the program. So I still think it's worth getting some details out on the program, but with the big caveat that this information might all be stale in a number of days. But I thought it'd be worth jumping in real quick. So very briefly, this parole program, some people are calling it Parole-in-Place, some people are calling it just parole, some people are calling it Keeping Families Together. No one really knows. It's all very new, but it's all the same thing. The idea is for someone who came to the United States without permission, generally, they're not able to get a green card in the United States. They have to go back to their home country to attend an interview at the consulate or the embassy, the U.S. consulate or the U.S. embassy in that home country. And if that person has been in the United States for over a year without permission and then they leave, they can't come back for 10 years. So there's a waiver for that bar. In that waiver, again, there are exceptions to all these rules, but generally that waiver can be done in the United States, but it takes forever and it's expensive and they're hard. The person has to show that their citizen spouse or parent or permanent resident spouse or parent would suffer extreme hardship if the person's not granted permanent residence. So they take a while, they're expensive, and they're hard. And so the purpose of this parole program, the person, the applicant is not actually going to leave, but if the person gets this parole, that parole allows the person to apply for their green card in the United States without having to leave, without triggering that bar, and without needing the waiver, without having to show extreme hardship to anyone. So, briefly, the requirements are pretty straightforward. The whole program has been pretty straightforward. I was expecting some glitches or the system to crash or some technical difficulties. It's all been very easy. Everything's done online. So, the requirements pretty straightforward. Number one, the person has to be married to a citizen as of June 17th, 2024. So if the person wasn't married or if the person was married to a permanent resident who wasn't a citizen at that time, not eligible. The person has to have been in the United States for the previous 10 years, so back to June 2014. And that's essentially it. Marriage to a citizen, and continuous residence in the United States for 10 years. There's certain criminal bars, too, that are probably going to be outside the scope of this video. If the person has any felonies, they're not eligible. If the person has any, there's a list of certain kind of misdemeanors, drug cases, sex cases, gun cases. So that gets a little bit complicated. In fact, the regulation says that if the person's got anything apart from minor traffic offenses, then that's a presumption against eligibility. Presumption you can overcome, again, outside the scope. I want to make this quick. So the form is all done online. It's the I-131F. I'll drop a link to the filing guide. There's a filing guide. There's a link. I'll put all this in the comment section or not in the comment section, but in the description box below. Filing fee is $580. And one of the points I wanted to make was I've been getting a lot of calls about this, and now that I've got a few under my belt, I think I can say with more confidence that the process is very straightforward. There's not a lot to upload. You're going to upload your you have to have like an identification document, passport, driver's license, some kind of government issued ID. So you upload the government ID, you upload, the proof that the spouse is a citizen, so either a birth certificate if they were born in the United States, or naturalization certificate, or certificate of citizenship if they were not born in the United States. Marriage certificate, if it's a second marriage, then they also need the divorces on either side. If you've been married before, or if the spouse has been married before, they need all those divorces plus the marriage certificate. And then it's that continuous residence evidence. So they're looking for not something from every day of every week of every month of every year for those 10 years. But I think kind of the best practice is to do something from every few months, every other month, or every 3 or 4 months. But there is no real rule. The rule is they're going to look at it, and under the totality of the evidence, if they think that it's more likely than not that the person's been here for 10 years. So school records are really good if the person was in school, pay stubs, bank accounts, but the bank account should only be in the account of the applicant. If it's a joint account and the statement doesn't break out like whose activity is whose, and that doesn't really help. Utility bills, that sort of thing. So my point there is, speaking as a lawyer, it's my legal opinion that with a clean case at least. Now, if there's I got a call the other day, oh, well, I'm married to my spouse, but we're common law married. We don't have a marriage certificate. Well, that person should probably have a lawyer. Or if there's any criminal history at all or any question about a criminal history at all, that person should probably have a lawyer. But for someone who's been for 10 years, came without permission, married to a citizen as of June 17th, 2024. I don't think that person needs a lawyer. If that person wants a lawyer, that's a different issue, and that's totally fine, and I understand that too. But I think that a lot of these lawyers are overcharging. These are taking about an hour, hour and a half, 2 hours tops. The point is, I don't think that a lawyer is necessary for a clean case. Now, if there's any question about whether it's clean, then yes, feel free to reach out to a lawyer. Or if it's just a peace of mind issue, that's fine too. So that's going to be it, I think, for purposes of today's video about the explanation. Lawsuit was filed yesterday by the state of Texas, which the immigration lawyer community was basically prepared for. This is exactly what happened with DACA, with the expansion of DACA, with DAPA from, I think, 2014, I want to say that was. So we'll just have to see. That's been filed. The court's going to rule. The merits of the case are going to take longer, obviously, but the court will decide on the injunction probably within the next few days. So maybe I do another video there if there's news there. If not, then I'll just put an updated link in the description box. I'll try to make sure that's clear. So who knows? If the injunction goes through, injunction means that the government won't be taking any more new cases, depending how the injunction's worded. Maybe they don't even decide any pending cases. So as I often say, we'll just have to see. But that's, I think, good for today. Again, it's Friday morning of August 23rd, 2024. So that's maybe the current status of Biden's Keeping Families Together parole program. Thanks for watching. Let me know any questions in the comments below. Thanks a lot.